Welcome everyone to lecture number 28.4 of the political science. So in this lecture we are going to discuss about article number 15. Okay, till now we have discussed till 12, 13, 14. We have discussed all the aspects of it. You can go through the previous lecture and it will be easy for you to understand. Okay, now article 15, that is also come under the part 3 of the fundamental right. What does this article 15 tells? Article 15 prohibit us from the discrimination on the ground of religion, sex, caste or place of birth. Okay, so what exactly it does? It prohibit the discrimination. It prohibits the discrimination on the basis or grounds of religion, race, caste, sex or place of birth. Okay, on these ground it prohibit us, it protect us from the discrimination. So article 15 protect us from any discrimination that is related to the religion, race, caste, sex, place of birth and all. Okay, but there is an exception for it also. We'll see it later. Proceeding ahead, will complete this article 15 whatever the aspects are present under it. Within the article 15 we have article 15 clause 1. Okay, what does this tell? See, it tells that the state shall not, state, what is the definition of state? That we have discussed in article number 12. Okay, so the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. Okay, and this right is enforceable only against the state, not to the individual. It means individual can discriminate but not the state. State includes like the government entities, government policies, government bodies like a State Bank of India and all. Okay, all those things will be considered under the state. Okay, so what this article 15 clause 1 tells? It tells that the state shall not discriminate against any citizen on what ground? On grounds only of religion, race, caste, whatever the things I have mentioned above, all those things, sex, place of birth or any of them, or any of the mentioned above. Okay, now this right, what I am telling right now, this right that which has been mentioned, so this right is enforceable to whom? This right is enforceable to state only. Okay, only against the state. It means that the government can't make any policies on the basis of religion, race, caste, sex and all. Government can't make those things. Okay, so this right is enforceable only against the state and not on other individuals, okay, not so let us suppose, so it means like indirectly, in other term, in other word, this means that citizen can discriminate. citizen can discriminate. So where these things we can see? Let us suppose in temple it is said that from today uh, only the Hindu can enter into the temple, no other religion will enter. Okay, so that is the law. As per the law, that can be proceed, that for this temple, for this place only on the basis of religion that Hindus are allowed. So that can be done. Okay, that can be done. But government can't make any such policies where the government may tell that the application for the railway government jobs only Hindu can fill the form. No, this can't be done by the government. This can't be done because as per the Article 15, a state cannot discriminate against any citizen on the ground of religion, race, caste, sex, place of birth, or any of the above. So like only for regarding this mentioned point, the state cannot discriminate. So okay, so discrimination can be done on the ground of like lack of admission in college. So yes, on what cases the government can do the discrimination? Discrimination can be done. Let us suppose in the admission of within the IIT college, yes, government can make the form and fill the form, like if you pass the exam then only you will be taken admission. So that kind of discrimination is allowed. Okay, but discrimination in the college admission on the ground of educational qualification, that can be done, but on the ground of religious qualification, that cannot be done. Okay, that if you are Hindu then you are only allowed to take admission in the college. No, that can't be done. But yes, on the ground of educational qualification, yes, government can do so. Okay, so what I'm trying to explain, that discrimination can be done on other ground like lack of admission in college because of educational qualification, Okay, so discrimination can be done on this basis. Now this was all about present under the Article 15 clause 1. Now we can proceed to Article 15 clause 2. What does this mean? Now from the Article 15 clause 2 we derive that no citizens shall on ground only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, place of public entertainment, or the use of wells, tanks, bathing ghats, roads, place of public resorts. Okay, so what I'm trying to explain, no citizen, even no private premises, can make such law that will prohibit such person to enter into the religion on the basis of the discrimination on the basis of religion, caste, sex, place of birth and all. Okay, they can't do. Let us suppose you are trying to enter into a restaurant and restaurant has told that no, you can't enter because you are of such a particular religion A, and we don't allow entrance of the particular religion A into our restaurant or into our hotel. No, they can't do so, because for Article 15 clause 2 they do not allow any citizen to follow the discrimination on the basis of religion, caste, sex, or place of birth and all. Okay, so as per Article 15 clause 2, no citizens shall on ground only. So if you see that I'm repeating the same thing again and again, but there is a different meaning to it. Religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability. It is not that liability. What is in liability? Let us suppose Hindu people is also entering the same restaurant, and Hindu people is also entering into the same restaurant. Okay. Now there is no liability on the restaurant that they have to take Hindu people only. If the hospital, if let us suppose only one room is left, so there is no such liability that okay, if okay, then we will take Hindu people in our room, or the Muslim people in our room, and we will discriminate Hindu on the that person as on the basis of his religion. It is just for example. Okay, we can't do no. Nobody is liable to any particular citizens on the basis of religion, race, caste, place of birth, or sex. Okay, understand? I hope it is very clear to you. Liability, restriction, there is no restriction. You can't discriminate, or you can't have any restriction on the basis of these such mentioned points. Okay, restriction or condition, there is no such condition with regard to what? With regard to, now we'll see what are those regards. With regard to access to shops, public restaurants, hotels, and places of public entertainment. Okay, or the use of wells. You can't discriminate any person by using any wells or drinking water from the river or tanks. You can't do so. Okay, the use of wells, tanks, bathing ghats, or are allowed to use such premises. Ghats, roads, and places of public resort, maintained wholly or partially out of state funds. Or dedicated to the use of general public. So what does this statement means? Like that statement we understood that we can't discriminate any people by drinking from the well, tanks, bathing ghats and all. Okay, but where this thing is applicable, it is applicable to where the government is funding, where it is for the general public. Now you can't tell that I want to enter any private property and I want to drink water from his house. Okay, no, you can't do so. It is not a government property. It is not funded by the proper government. It is not used for the general public. It is completely belongs to the private property. Okay, you can't do so. But yes, if there is a general public places where let us suppose ghats is there, so you want to drink water from the Ganga river and nobody is allowing you to do so. Okay, nobody allowing you to drink water from there, so nobody can do that. As per the Article 15 Clause 2, you have the provision that you can use as per your will. Okay, you can drink such water. You can't do such discrimination to a person. Okay, so what I'm trying to explain, So whatever the things that we have discussed in Article 15 Clause 1, it is for the state. Okay. Whatever the things that we have discussed within Article 15 Clause 2, it is for both state and citizens. Understood? Whatever things that we have discussed in Article 15 Clause 1, it is only for the state. Whatever things that we have discussed in Article 15 Clause 2, it is for the state and citizens both. Okay. So discrimination, now here is the exception of it. Now here is the exception of it. What is the exception? What is the exception? We'll see. The exception is that discrimination can be done on the ground of medical ground. So discrimination can be done on the ground of medical. Let us suppose one person is suffering from corona and that person want to drink water from that well. So it means like, no, on the medical ground that person is not allowed to do so. Okay, we can do a discrimination of it. On the medical ground, let us suppose if a person is suffering from a TB, tuberculosis, we can't allow him to drink water from that well. Okay, so, and there can be a multiple ground, then not only on the basis of medical ground, there can be more multiple grounds that can do. Let us suppose a flood is going there, flood is happening, or a river is fast flowing, and we can see that a very lean thin and person going to drink water, or let us suppose a lady is going to drink the water on that scenario. Will not allow her to go and to stand near the water, because the current of the water is very high. Okay, and it is dangerous. So in that case also the discrimination can be performed. Okay, let us suppose one more thing, like military officials are doing their work, and on that basis, and you are trying to interfere with their work, so that can also not be done. Okay, so on various grounds that discrimination can be performed. Okay, now one more clause for the 15.2, within Article 15 Clause 2, one more ground will be there. It is enforceable against a state as well as an individual, what that I have just now mentioned. Enforceable against a state as well as individual. Okay, it is enforceable to both one, and it helps in fighting against untouchability. So this Article 15 Clause 2 help us in fighting against untouchability. So it helps in fighting against the untouchability. Okay, I hope you are understanding what I'm trying to explain. Okay, now exception is mentioned in within the Article 15 Clause 3. So discrimination on the basis of the sex can be done. Okay, now what does this Article 15 Clause 3 tells? We'll discuss it here. Article 15, let me expand it. Article 15 Clause 3, what does this tell? So nothing in this article shall prevent a state from making any special provision for the women and the children. So Article 15 Clause 3 tells that there can be exception, there can be a discrimination on the basis of gender, that is sex. Okay, so nothing in this article shall prevent the state from making any special a special provisions for women and children. Okay, so now it is not, article 15 is not stopping the state from forming any special provisions for the women and children. In short, article 15 clause 3 is not prohibiting the state on the discrimination basis of the children and women. Okay, so what does this article 15 means? Article 15 is telling lot of things. Okay, first it is telling that we can't discriminate. Now in another term it is telling that we can discriminate. So what exactly it is going on? What exactly it trying to say? Oh, so article 15, so in short, article 15 is not absolute. It has exception. Under article 15 clause 3. What is that ground? On the ground of sex. On the ground of sex or gender. Okay, another exception. Initially this was still article 15 clause 3 we have. Now another exception was added. Initially it was not a part of constitution, added by the first constitutional amendment act in 1951. Okay, so article 15 clause 4 was added to the constitution by the constitutional amendment act, the first constitutional. It is the first constitutional amendment act that was done in the year 1951, and it was also an exception. 15 clause 3 also considered an exception, and now 15 clause 4 also considered an exception. Okay, so Madras government said that there will be a reservation for SC/ST in our government jobs, engineering and medical colleges. The state was trying to discriminate on the basis of caste. Okay, so the Champak Darai Rajan versus State of Madras in the 1951 Parliament got together and amended the constitution with article 15 clause 4. Okay, now another exception was added. What was that? So it does not bar the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Okay, for government or private aided institution this will be applicable. Okay, so what was that? What was this article 15 clause 4 are telling that? So article 15 clause 4, it does not bar the state from making any provision for the advancement of any socially and educationally backward classes of citizens or for SC and ST, and this will be done for the government and private aided institution. Like if private institution getting fund from the government, so those things will be also considered under this. So okay, so now government can make any law where it will discriminate on the basis of caste. And why they will discriminate? They will discriminate for the advancement of any socially and educationally backward classes of citizens, to uplift the backward society or backward people, to uplift those such people within the society. Government can do so. Okay, so this was done through the Constitutional Amendment Act, first Constitutional Amendment Act of the 1951. okay, and it was done through the, like, this was brought up, the state was trying to discuss, so this was brought up through the Champak Dorairajan versus state of Madras, okay, in 1951. It was brought up through this case, okay. So there will be a, so this was ordered by the state Madras government only, like Madras government said, like, we will need a reservation for the SC and ST in government job, engineering and medical college. So now the state was trying to discriminate on the basis of caste, and this was brought up in this case, Champak Dwai Raja versus State of Madras 1951, and then they brought up with the Constitution, first Constitution Amendment Act, where they can discriminate on the basis of caste to uplift such people who are in the lower strata of the society, to uplift those such people, okay. Now another amendment came. First amendment happened in 1951. Now another amendment happened in 2005, okay, as the 93rd Constitutional Amendment Act, okay. First was done in the 1951, and it was the first Constitutional Amendment Act. Now the second was done in as the 93rd Constitutional Amendment. It was in 2005, okay. And now here Article 15 Clause 5 was added. What was that? So it confers power on the state to reserve seats in the favor of backward classes of citizens who are socially and educationally backward in educational institutions, including unaided private institution, but excluding the minorities institution, okay. What are the minority institution? We are going to see in the Article 30 with respect to it, okay. So Article 15 Clause 5, it confers power on the state to reserve seats in favor of backward classes of citizens who are socially and educationally backward in educational institutions, including unaided private institution, but excluding the minority institution. So what it basically means, like earlier we were doing on the basis of caste, okay. Now it is telling the power to the statement to reserve in the seat for the any backward classes for the citizen, if there is a particular class, okay. So on that basis also we can do the discrimination, okay, such as other backward class, OBC, okay. Earlier it was only SC ST ground we were including it. Now OBC will be also included under it. So now that provision was not given under earlier, only on the basis. Article 15 Clause 4 was also telling that we can do the reservation and all, but it was on the basis of it was mainly on the basis of caste and all, okay. So now then another amendment was added in the Article 5 that we can do favor for the reservation of the seat for the backward classes of the citizens who are socially and educationally backward, okay. On the basis of education also, if they are backward, so we can do a reservation for them. So after 2 years, the Parliament of India passed another law. After 2 years of 2005, Parliament of India passed another law that was known as the Central Educational Institution Reservation of Seats Act, okay, CEI Act of 2007. Reservation of seats was happening, okay. So here it was declared that not more than 27% of the seats in centrally educationally institutions such as IITs, IIMs, NITs, okay, on such institution have been reserved in favor of the OBCs. Okay, so now as per the another law was formed that not more than 27% OBC will be getting reservation. Maximum that OBC will get the discrimination will be the 27%. So purely and further those such institutions like that comes under the centrally educational institution like IITs, IIMs, NITs. Okay, but purely if there is a if there is a purely there is exception for it, that's why I'm telling you. So purely research oriented institutions like PIFR or space related agencies and all, so, okay, so have been exempted. So if we are exempted on those such places also, then country is in loss. Okay, so what is the current percentage? Again, like again a Constitutional Amendment Act happened, 103rd Constitutional Amendment Act 103rd happened in 2019 by the Modi government. Wow, in that amendment it was given that economically weaker section will also be getting 10% reservation. Okay, then Supreme so this was added newly. So what is the current percentage scenario? So SC is having 15% reservation, ST is having 7.5% reservation, then OBC is having 27% reservation, and disability related people are having 4% reservation. Okay, so 10% reservation for the EWS. So SC will be getting 15%, ST will be 7.5%, OBC 27%, and disability related reservation will be 4%. Okay, I hope you have. So yeah, we have discussed about this 103rd amendment. Okay, but we haven't discussed about those things in detail. So I'm covering that part also within this lecture only. Okay, so we have discussed till Article 15 Clause 5 what it tells us. Okay, now there are certain things that happen in 103rd amendment, and through that we got the 10% reservation. Okay, and we have seen we will be getting to know that the maximum cap, the reservation can be provided was 50% only. So when this EWS was getting introduced, so the question was raised, so how when we have a cap of 50% reservation only, then how we can give a EWS as a on top of it reservation of it. Okay, how we can do so? So the whatever the 50% maximum cap is allowed in the constitution for the reservation is on the base of caste, okay, and this EWS is not based on the caste, it is based upon the economical weaker section. Okay, so that what happened. So let me I have used this chat GPT for the, I'm not getting exactly the consolidated answer, so I'm used this AI tool, so that we'll get a proper answer for it. Okay, so the question was raised that what were the amendments that were actually done in the 103rd constitution. Okay, so the within the 103rd constitution amendment, there were like this provision was not given in the in our constitution that we can go ahead more than the 50% reservation. So they amended the constitution. So the constitution was amended by the Modi government, and they were in a very high majority. So it was a piece of cake for passing that amendment for them. Okay, so the 103rd amendment of the Indian Constitution, officially as known as the 103rd Amendment Act in 2019, it introduced 10% reservation for the economical weaker section of society for the admission of the central government run educational institutions and private educational institutions, except for minority education. There are, let us suppose there is a school that is only for some minor section of the society, so in that case that won't be applicable. Okay, that in that case that won't be applicable. Okay, so there were two amendments of the clause that were introduced within the constitution. Okay, what were the two amendments? The two amendments were done will added as of article 15 clause 6 and article 16 clause 6. Okay, what exactly the article 16 will discuss in article we will discuss that thing in article 16 when we are going to, in the next lecture we are going to learn about article 16. So okay, so we'll discuss that thing over there also. So in the article 15 clause 6 it was added that it empowers the state, article 15 clause 6, it empowers the state to make a special provision for the advancement of economical weaker section. There was nothing included under the constitution related to the economical weaker section. Whatever we have discussed till now, it was related to caste, sex, religion and all. Okay, but there was nothing related to economical aspect. Okay, so the Modi government, the ruling government, amended the constitution and added the advancement on the that we can make a special provision on the advancement of on the basis of economical weaker section of the citizen. In matter of what? In matter for the admission of education institutions, including private ones, whether aided or unaided by the state. Okay, so it can be the education institution can be aided or cannot be aided by the state. So there can be a special provision if government want to make, they can make, except the minority education institution referred to in the clause 1 of the article 30 of the constitution. Okay, what exactly is present under the article 30 clause 1, we'll discuss it. What because every time we are hearing that minority term is coming. Okay, so for sake of now, minority education institutions are exception for it, whether government can empower any regions with, whether it private ones also, whether it is aided or unaided by the state, they can make a special provision related to the economical weaker section. Okay, so now when this amendment was done, then after government came up with the reservation of economical weaker section by the 10%. Okay, now what exactly was added in article 16 clause 6? What was the amendment? So article 16 clause 6 empowers the state to make a special provision for the reservation of appointments of the post in the favor of economical weaker section of the citizens other than class mentioned in the clause 4 of article 16, subject to a maximum limit of 10% of the post in each category. Okay, in each category. Okay, so we'll discuss about article 16 in the next session. So this was done the amendment within the 103rd constitutional amendment. Okay, I guess it is very clear. So the amendment also defined economical weaker section as those who are not covered by the existing reservation for the scheduled caste, scheduled tribes, other backward class, like OBC was there, scheduled caste was there, scheduled tribe was there, but there was nothing related to the economical aspects. Okay, the central government has then notified that the person who has a family has a gross annual income below rupees 8 lakh to be identified at EWS for the benefit reservation. So okay, so this 8 lakh term is a threshold. Okay, and this threshold will be updated over a period of time. Okay, so it depends upon the central ruling government what cap they are going to fix. Okay, let us suppose as when implemented, so they put a cap of 8 lakh. So if the whole family, okay, if the whole family is earning below rupees 8 lakh, then it will be notified under the EWS. And there were certain more conditions were present under the EWS, like there won't be a house in a personal house in a urban area, or there was some amount of land that will be included. So okay, there were many terms and conditions related to it. So the main aspect that we have to learn, that EWS was introduced through the constitutional amendment that was done through the 103rd constitutional amendment, where the amendment was done with it was added as article 15 clause 6 and article 16 clause 6 were added within the constitution. Okay, so this was all about within this lecture. I hope you have understand it. Okay, if there is any doubt, please connect with me on social media handle, and this is a new channel, we really need your support. Please subscribe the channel. Thank you.